after that procedure is over, then the matter should be listed, my lord.
Yes.
My lord. Now, as per my lord and friend, the has already taken over. And
There is one noting saying heard in part. No?
On the last occasion, it was posted for court number 3.
That's what.
Yes.
The roster is changed, but there's a noting saying heard in part. So formally it will have to be released. The next one was sort. Yeah, but it has to be. I think it has to be formally released.
Yes, madam.
Not there? Oh, I see. That's this court, is it? All right. Carry on, carry.
My lord, in this case, the learned tribunal has allowed the SENVAT credit on the power plant. Subsequently, it has been merged with NINL. My lord. On the last occasion, I have placed before you in twofold. First, whether two separate registration is required or not. And second, when NINL and the present respondent are two separate entities, in that case, when respondent is manufacturing, generating electricity, and at the relevant period, there is no commercial production has been started so far as the respondent is concerned, and the total electricity is being transferred to NIN. In that circumstances, so that SENVAT credit is available to the respondent. My lord, kindly see, I have given the rule 174 of the Central Excise Board. I have given the relevant pages of the rule.
Right.
My lord, registration. Every person who cures, produces, manufactures, carries on, trade, deals as a broker or commission agent, holds private storeroom or warehouse, or otherwise use excisable goods, or a person who issues invoice or invoices under Rule 57 AE shall get registered and shall not engage in the curing, production, manufacture, trade, dealing as broker or commission agent, storing in private storeroom or warehouse, or use excisable goods without having applied for such registration to the jurisdictional range officer in such forms as may be specified by the. My lord, kindly turn to sub-rule 3. My lord. If there are more than one premises requiring registration, he shall obtain separate registration certificate for each of the premises. In this particular case, my lord,
And sub-rule 5 also, no?
pardon, my lord?
Sub-rule 5 is also important.
My lord, where a registered person transfer his business to another, the same shall obtain a fresh certificate. It is after transfer of the AAB. So far as the registration is concerned, my lord, in the present case of the respondent, there are two premises has been used. One is for coke oven plant, and another premises inside the NINL for generation of electricity. So there are two premises. And if your lordship will come to the paper book,
No, the sub-rule 3 says if there are more than one premises requiring registration.
my lord, here,
When is registration necessary?
my lord, here, because that has been clarified. If your lordship will come to the paper book I filed,
Supplementary instructions regarding registration.
my lord. If your lordship will come to
Persons requiring registration.
that's
2.2, I think. Just see 2.2
2.2
of the supplementary instructions.
compilation.
Page 31.
Yes. The compilation.
BC exercise manual or supplementary instructions.
My lord, I'm coming. Separate registration is required in respect of separate premises, except in case where two or more premises are actually part of the same factory, where processes are interlinked, but are segregated by public road, canal, or railway line. The fact that the two premises are part of the same factory will be decided by the Commissioner of Central Excise based on the factor in such cases. Here,
Why are you not reading it? It's relevant, sir. Why are you not continuing to read? What is written there is relevant for the case.
my lord, interlinked process, product manufactured, produced in one premises are substantially used in other premises for manufacture of final products. Large number of raw materials are common and proposed to be received commonly for both and all the premises. Common electricity supplies, common labor workforce, common administration work management, common sales tax registration and assessment, common income tax assessment, any other factor as may be indicative of the interlinkage of the manufacturing process.
So this is important.
My lord,
If the two premises are part of the same factory.
same factory.
Ah,
Here,
and it's under
admittedly,
the same management.
my lord, the word substantially used in 2.2 clause 1 roughly used is the most important factor in this case, because admittedly the respondent has admitted themselves the total generation out of the total generation of electricity, 75% will be used by NINL.
What is not substantial?
No, sir. No, your lordship kindly see 25% will be used by the respondent. 75% will be supplied to NINL. NINL is not the same entity, my lord. It is the
Once it's taken over, I don't understand.
it has been taken over subsequently, my lord.
Whatever.
My lord.
We have to see at the time of takeover, what is the position, correct?
My lord, but the input, but the Senbat credit is being they have taken in the year 2001, my lord.
So what?
And commercial production of the respondent has started in the year 2004.
Okay.
And total electricity is supplied to NINL, which is another unit. So the word phrase substantially used is not there first. Then interlinkage is also not there, because there is no finished product so far as the respondent is concerned.
No, interlink means this becomes input into that other product, final product.
Yes, my lord.
Is it contributing to the manufacture of the final product? That's what interlinking means, sir.
But at that moment, interlinkage was not there, my lord.
If the supply is 70, whatever, if it's being supplied to NINL, how will the interlinkage not be there? Electricity goes to that place.
NINL is a separate unit, my lord. Separate
You're
entity.
confusing the two things, sir. You're confusing the two things.
My lord, NINL is a separate entity, my lord.
Sir, the point now is there an interlinkage?
Interlinkage so far as the finished product of the respondent. Interlinkage is the so far as the finished product of the respondent, manufacturing of the finished product of the respondent, my lord.
Anyway, yes.
My lord. Then, so far as the registration is concerned, my lord, there is a clarification by the board, my lord, which has been quoted out by my lauded friend in their counter affidavit, my lord. If your lordship will come to the paper book at page 124. Your lordship got it?
Yes, please.
Para 11. The respondent craves leave of this honorable court to rely on the guideline issued by the Central Board of Excise and Customs in their manual of supplementary instruction dated for each for ease of reference. The same is extracted below. Separate registration is required in
You just now read the whole thing. You're reading
my
it
lord,
again?
my lord. That there, my lord, there is
Just
a
now read this.
my lord, in this notification, there is a bar to take separate registration. If there is these are being separated by roads or railway line or canal, my lord. Here, the two premises are in two different places. One is situated, the respondent's factory is situated at the side of the NINL, and the power plant is situated inside the premises of NINL. That is admitted by. Once there are two, and the finished product of the respondent is coke, and the finished product of the power plant is electricity. And so far as the electricity, when the respondent has supplied the entire generation of electricity to the NINL, at that moment the electricity was exempted from central excise. And there is a bar. In that circumstance, there is a bar that once the goods are exempted, you cannot take central credit on the capital goods used in those manufacturing of the goods. If your lordship will come to compilation, page number 26, man.
Yes.
My lord, the bottom two lines, clause 3, my lord.
Yes.
No credit of the specified duty shall be allowed on capital goods which are used exclusively in manufacture of exempted goods, other than final products which are exempt from the whole of the duty of excise leviable thereon under any notification where exemption is granted quantity of clearance of the made in the financial year. In the present case, it is admittedly they are generating only electricity at that time, and it is being exempted. So under clause 3, there is a bar to take send back credit on those.
That's it. Yes.
And the decision relied upon by my lord and friend in all those decisions, that is distinguishable in the facts of the case, my lord, because in those decisions, everywhere the substantial used has been electricity which are being generated has been used by the assessee substantially, and the rest are supplied to the other.
Yes. Yes.
Please. My lords, the question, my lord, for kind consideration is whether the credit on capital goods used in the power plant for generation of electricity, when admittedly part of the electricity is used by the company which has taken credit, and substantially the remaining part, 75%, is used by NINL. The only rule, my lord, which my learned friend read in 5783 is when the capital goods are exclusively used in the manufacture of exempted goods, can credit be denied? In my case, my lords, I am manufacturing coke, which is a dutiable product. NINL is in turn manufacturing other iron and steel products which are dutiable, namely pig iron, billets, etc., which are dutiable. The electricity which is generated, the electricity being an intermediate product exempted, is of no consequence for availment or denial of the credit. In fact, on that point, Commissioner decided in my favor, saying that the contention of the department that electricity is exempt and therefore credit is not to be allowed is not acceptable. Against that part of the order of the commissioner, department did not file appeal before the honorable tribunal. Therefore, that has attained finality. Therefore, my lords, the only question is whether I am eligible for credit on the capital goods used in the power plant when part of the electricity, even if it is substantially used outside by somebody else, whether I am eligible for credit. Do I fall within the exclusion under the rule 5783? Can I be said to be using the capital goods exclusively for exempted question, my lord, which came up for consideration before different high courts? The case was of the department in those cases, similar to my case, was that electricity is substantially being supplied to the grid or to a third party. Therefore, the assessee was not eligible for credit. The Honorable High Courts considered the fact that the provisions require exclusive use of the capital goods for manufacture of exempted goods. So even if some quantity of the electricity is used by the same manufacturer for manufacture of dutiable products, credit cannot be denied. That is what, my lords, the Honorable Chhattisgarh and the Honorable High Court of Madras has taken a view. Therefore, in my case, and that's what the tribunal has also given a categorical finding, that the fact that electricity is supplied to the other unit cannot be a ground to deny the credit in the facts and circumstances of the particular provisions. That's, my lords, the entire case of the department. And to the extent to say that there is interlinkage of the production of the entire unit, my lords, if I may point out, this entire factory, my lords, was set up based on a common feasibility report. The entire company, NINL, was formed as an integrated steel plant for manufacturing of steel stage. For strategic reasons, initially, the feasibility report itself indicated that they'll have two entities, namely Konark Metcoke, the respondent here, and NINL. Konark Metcoke will have the power plant and the coke oven plant, namely to manufacture coke. NINL will have the blast furnace and other steel melting shops and other facilities for manufacturing the final product steel. There is complete interlinkage of the production in as much as the coke which is manufactured in the power plant is by NINL as a substantial raw material for manufacture of steel. Similarly, my lords, in the blast furnace, when the molten metal is manufactured, inevitably the blast furnace gas emerges, which, my lords, comes out of the furnace at about 800-900 degrees centigrade. That gas, in fact, is used to run the power plant. So the entire setup was, my lords, in a manner where there is complete interlinkage of production of the NINL with Konark Metcoke. In fact, that is the reason immediately after commercial production started, the companies merged into one single integrated such from 2002 onwards till 2004 onwards till today. Therefore, my lords, and that is how the entire setup
was. What is the period we are talking about?
My lord, the registration of this Konark Metcoke took place in 2098. Credits were taken from 2001 onwards, my lords. Credits were only taken as book entries because neither did Konark start the commercial production nor did NINL start the commercial production. Because of these requirements, if a manufacturer is manufacturing goods, they had to take registration. And because I had to procure goods from various customers, I had to issue C form under the sales tax, etc. The companies took registration 8 and then they were receiving the capital goods. The complete plant was being set up during the period from 98 till 2002-2003, when in a phased manner, the complete production, commercial production started. So during the period when the credit was taken, NINL was generating electricity which was partly used, the Konark Metcoke was generating electricity which was partly used by them. Admittedly, 25% was used by them only. 75% was given to NINL. In fact, my lords, if I may point out, even though there were two separate companies in the initial phases, it was a captive power plant. The duty was also paid as a captive power plant.
Captive of which?
Of NINL. Ultimately, it's a captive power plant, both because the company is one. In 2004, when the entire company was merged into NINL, it is all became a captive unit.
What is the period of assessment or whatever we are talking of? What is the period?
My lord, the credit that is being taken here is for the period, my lords, from March 2001 to July 2001. When credit was only taken, was only an entry in the books.
During this period, that is March to July, had both the entities merged?
My lord, by the time it was not merged. Subsequently, it is merged. The subsequent facts, my lords, if you take into account and the fact that the initial feasibility report itself indicated clearly that these are being by two companies for strategic reasons and ultimately they will merge. The intention was to merge into one.
No, that may be. But for this period, March to July, they had not merged.
They are not merged.
They were two separate entities.
Yes, they are two separate entities. The question, my lords, for my lords, kind
And the
consideration.
SSC is Konar.
Yes, my lord. The
Metco.
SSC is Konar, which had installed capital goods in the power plant,
Yes.
which was generating electricity,
Right.
which had also a coke oven plant, which ultimately where coke was manufactured, ultimately cleared on payment of duty, which is a final product. So whether this entity, which had the power plant and the coke oven, can they goods when part of the electricity or substantial part of the electricity is given to NINL? That's the question.
Yes.
The rule says only if it is exclusively used for manufacture of exempted goods, credit is to be denied. And that is what precisely the Honorable High Court, my lords, of Chhattisgarh in the case of HEG. My lords, may please take my compilation at page 37.
Yeah, NINL was there. But they were separate.
7, my lords.
Yes. HEG Limited.
Para 1 itself, my lords, the questions all which are before the Honorable High Court. Whether it will be in violation of Rule 2H, 2G, Rule 6.4 of the SENMAT credit rules, if SENMAT credit is allowed to the respondent on electricity generated captively, but instead utilizing it through distribution lines of MPEB, whether the tribunal has erred in allowing the credit on the impugned goods in toto, instead of allowing proportionate credit on electricity consumed within the factory.
No. So there are no two entities here at all then.
Well, in fact, it was given to the
separate
grid.
entities,
Yes,
like we have in our case.
There's no separate two entities. There are only one entity, power plant partly generated, substantially supplied to the grid. Can it come within the restriction of the electricity being used or the capital goods used exclusively for manufacture of finished goods was the question. The Honorable High Court, my lords, at paragraph 12.
No, but did they interpret this substantively used?
Yes, but exclusively used. My lords, may please come to page 38, paragraph 6, my lords. The rule which my learned friend read just now, 5783. Successor rule is at extract is referred at page para 6. May I read, my lords?
Yes, please.
On the other hand, the so-and-so learned counsel appearing for the respondent submitted that from a bare reading of Rule 6.4 of the rules, it is evident that SENMAT credit may be denied on such capital goods which are exclusively used in the manufacture of exempted goods. In the instant case, electricity generated in the captive power plant of the respondent is utilized for production of the final product sponge iron, and only surplus electricity is sold to the MP Electricity Board through their grid. And therefore, it cannot be said that power plant are exclusively used in exempted goods. In my case also, admittedly, 25% is used by me for manufacture of my coke. Only 75% is given to NINL. Therefore, can it be said to be used exclusively in the manufacture of exempted goods? That's what this Honorable Court answers, my lords, at paragraph 11. The only question to be decided in this appeal is whether the tribunal was justified in allowing SENMAT credit to the respondent for capital goods used in the power plant of the electricity generated was sold to MPEB.
You want to substitute MPEB by
NINL. Plain reading of Rule 6.4 of the rules make it abundantly clear that SENMAT credit in respect of capital goods shall not be allowed on capital goods which are used exclusively in the manufacture of exempted goods. In the instant case, though major portion of the generated electricity from the power plant are sold to MPEB through its grid, however, it cannot be said that the capital goods were exclusively used in the manufacture of exempted goods electricity sold to MPEB as portion of the electricity generated in the power plant is also utilized in the manufacture of final products, namely sponge iron of the respondent factory, which is leviable to excise duty and is not exempted goods. On the basis of the above analysis, we are of the opinion that the tribunal is justified to hold that the respondent was entitled for mod VAT credit to the capital goods used in the captive power plant of the respondent, and Rule 6.4 of the rules was no bar for denying credit. Similar view was taken by the Honorable Madras High Court at my lords, page 43, my lords.
Kothari Sugars.
Kothari Sugars, which was in fact followed, which subsequently the para 5 minutes. Following the tribunal decision in HEG, the Honorable High Court held that the credit cannot be denied when part of the electricity is being given to the other entity. In my case, my lords, I admit they are in fact their questions allow itself admit that 75% is given to NINL, 25% is used by me.
So tribunal held in your favor. In
Yes,
this
my
case.
lords. Tribunal held in my favor by holding that the fact that it is used given to NINL cannot be a ground for denial of the credit. The finding of the tribunal, my lords. Page 48.
So apart from March to July 2001, with this future, since you merged, this question doesn't arise at all.
In fact, my lords, the entire, if my lords, in terms of the judgment of the Honorable Supreme Court, subsequent events should be taken into account. And the fact that there is a complete one single feasibility report, which indicated that for strategic reason, these are being formed as two companies and will definitely will merge in future. And that is the reason why, my lords, initially also it was set up as an integrated steel plant to manufacture from the ore to the final product. So, and that was the intention always for strategic reasons because of financial requirements, etc. Two companies were initially formed, and that, my lord, subsequently, in fact, my lords, may kindly see my counter, my rejoinder, my counter. I have clearly indicated this fact also, and that's an undisputed fact also, my lords. About the common feasibility report, and that's a fact which is acknowledged by the authorities also. If you may kindly read page 123 of the paper book filed by learned friend, my lords. At page 124, top line, my lords. May kindly read. Page 124, my lords. MMTC is one which was the promoter of this company. It's a government of India undertaking.
Right.
And was on the basis of a single feasibility report, in order to meet the institutional norms pertaining to promoters' contribution, arranging, etc., it decided to promote bifurcate NIL into 2 units for setting up another company with the main objective of manufacturing blast furnace coke for exclusive use by NINL. It is pertinent that both NIL and KML merged from the same feasibility report, wherein all technical features and service are designed in a manner to make the industry unit as an integrated conventional iron and steel plant, and two are interdependent on each other, both technologically and operationally. Both the plants are interlinked and are integral or inseparable of each other and manufacturing so and so. And the feasibility tool said that they'll be merging separately. Therefore, my lords, to say that I am not eligible for credit on the ground that substantial electricity is being consumed, my lords, may not be correct on in the light of these judgments of these two.
Your Lordship, kindly turn to page 15 of the paper book.
Yes.
Relationship between NINL and the present respondent.
Yes.
If your Lordship will come to clause 6. NINL proposes to sell BF gas, converter gas, nitrogen gas generated from its steel plant, as well as provide water to KMCL and purchase BF, coke, LP steam, HP steams, coke, grease, and electricity produced generated from KMCL's coke oven plant and power plant. There is from this clause itself, your Lordship will appreciate that there is two separate entities. There is a agreement for purchase and sale. First thing. Then your Lordship, your Lordship kindly appreciate that the present respondent has started its commercial production in the year 2004. And electricity in the year 2001 was only being generated for NIN. There was no commercial production. Question of use of electricity in their commercial production doesn't arise.
For coke.
For coke doesn't arise. In those decisions cited by my learned friend, there some of the part of the electricity were being used for manufacturing of the finished product.
So here, that manufacturing of coke using electricity for this period did not arise.
Did not arise.
What do you say to that?
Well, the only question was during the time when I took the credit, in fact, there was no manufacturing by both the entities. Because it was a factory which was being set up. Even though registration was taken in 98, it was being set up. The entire erection, commissioning, etc. was happening, my lords. Therefore, when the capital goods, the power plant was being set up, credit was taken. The power plant erection commissioning was happening because that was the requirement under the relevant provision that I could take credit immediately on receipt. If it was the case prior to April 2000 or March 2000, till March 2000, under the moderate credit rules, credit on capital goods could be taken only after installation, which Malad provision changed from 1st of April 2000, when the law allowed for taking credit on capital goods immediately on receipt of the capital goods in the factory, 50% in the first, 50% in the subsequent year. So therefore, there was no requirement of actual installation and actual put to use of the capital goods. So therefore, the credit was taken in March 2001 to June 2001. When the capital goods were all procured, the boilers, turbines, etc. were all being used for erection, commissioning, installation of the power plant. Effectively, when the initial power plant was set up in 2002, etc., whatever electricity was being generated was used within the power plant itself for the electricity which was there for other facilities. Simultaneously, the coke oven plant also was being set up. Initial productions, trial productions, etc. were happening. Same period, the other NINL was setting up the blast furnace, was setting up the steel melting shops, etc. Completely, all the facilities in the steel plant effectively started in 2004. When immediate.
Yeah, that is therefore much after this period we are talking about.
Yes, but it is much after.
March to July, there was no manufacturing activity.
No, in fact, credit was just lying in my books. Only when I first manufactured coke and cleared, I utilized this credit also. In fact, I can take the credit, retain it with me. That credit is of no use for me because it is lying in my books. Only when I clear coke oven, when I sold coke oven to NINL, I was required to pay duty. I utilized the credit. That happened in 2002, 2003, 2004 onwards. Because some small quantities are being manufactured, which I was paying duty and taking. Therefore, and that's what their question of also says, 75% is used. Otherwise, their case would have been that during this period, 100% is used by NINL. Therefore, I'm not eligible for credit. Their case, Manoj, is 75% was used by NINL, only 25% used by you, by Konark. Therefore, we are not eligible for credit. And therefore, my credit is taken in 2001 because I was
even 75% to NINL. That is not being used by them for manufacturing of steel.
Subsequently, it is used, Manoj.
No, that's what this period. We are actually talking between March and July 2001, sir.
During this period, even NIL, Manoj, did not.
Correct.
Therefore, there is no question of, Manoj, the question of giving the electricity.
No, then these conditions don't get satisfied, isn't it?
No, the condition is, Manoj, used in the factory of the manufacturer. The condition, Manoj, of use of the electricity for manufacture of dutiable products is only in the context of inputs. For taking credit on capital goods, credit is taken on capital goods to factory. Unlike in the context of inputs, Malaj, I'm extremely grateful. Malaj, please come to my compilation. The definitions, Malaj, from 1st April 2000 at page 20. Page 21, Malaj. This is from 1st April 2000. It will apply for the relevant period also. Manoj, please come to page 22, sub-rule D. Yes. I'll read the definition of inputs first, then I come to capital goods, Manoj. Sub-rule D in the middle of the page. Inputs means, got it, Manoj?
Yes.
Goods except high-speed diesel oil and motor spirit used in or in relation to the manufacture of final products, whether directly or indirectly, whether contained in the final product or not, and includes accessories of final products cleared along with the final product, goods used as paint or as packing material or as fuel or for generation of electricity or steam used for the manufacture of final products or any other purpose within the factory of production, and also include lubricating oil, greases, cutting oils, coolants, etc. Therefore, for the purpose of inputs, I must show the use of the inputs used in or in relation to the manufacture of the final products, or for generation of electricity in the use within the factory of production of the final products. Capital goods definition in the top of the page, Manoj, says capital goods means all goods falling under chapter 82, 84, 85, which is where I get covered, used in the factory of the manufacturer of the final products. So I am a manufacturer of final products. I have got registration with an intention to manufacture coke.
No, the word input envisages there must be some commercial production already.
In the capital goods, the question here, Manoj, before is whether this is a capital goods or not the question. For inputs, Manoj, are right. If I suppose procure, say, fuel, furnace oil I procure, I take credit of the furnace oil. I generate electricity out of the furnace oil. Electricity is cleared to NINL, partly, substantially. Small quantity, I consume the electricity within my factory. The question is whether the duty paid on the furnace oil, whether I am eligible for full credit of the same. That issue, my lords, came up for consideration before the Honorable Supreme Court in the case of Maruti Suzuki, where the Honorable Supreme Court interpreted this provision to say, as far as inputs are concerned, the duty paid on the furnace oil in the example will be eligible to an assessee only if the electricity also is used. In that case, Maruti had taken credit of duty paid on naphtha used for generation of electricity. Electricity was consumed by Maruti partly it was given to its vendors. There the Maruti claimed that since the entire quantity of the electricity is being ultimately used by me because my vendors also manufacture parts which come back to me, the Honorable Supreme Court said no, Maruti will be entitled to credit only to the extent of duty paid on naphtha on the quantity of electricity used within the factory of Maruti. That is in the inputs. For capital goods, there is no such requirement. The only restriction for capital goods is 6.4, which says the capital goods, if they are exclusively used for exempted goods, only then credit will be denied. Malats, in the same compilation, which my learned friend read at page 26. We are only concerned with capital goods. Subrule 3, which Malats, my learned friend read. No credit of the specified duty shall be allowed on capital goods which are used exclusively in the manufacture of exempted goods. So this provision is only provision under which they can. Requirement of capital goods is used in the factory of the manufacturer. No further requirement of use of the capital, the electricity, etc. within the factory. Therefore, credit cannot be denied. And admittedly, their questions of law itself says when 75% of the electricity is cleared outside, can credit be denied? That is their case made out in the Shokas also. And the other contention, that electricity is exempted, therefore credit not to be allowed. The learned commissioner raised this issue. My lord, may please come to the order in original, which starts at page 53, the discussion and findings of the page 53, my lords, is the discussion and findings. Paragraph 2.3 minutes.
Page 53 of the compilation.
Of the paper book, my lord. Page 53 of the paper book, my lord, at internal page 13, which will be, my lords, at page 55. One of the questions considered by the commissioner was whether the fact, got it, my lords?
Not really.
On top of the page, internal page 13 of the order in original. The paragraph 2.2, my lords.
1 minute.
2.3.
Whether the fact that power is not
Whether the fact that power is not excisable by itself will disentitle KMCL from the SENVAT credit on inputs and capital goods used in the power plant. This was the question raised. The learned commissioner decided this question in my favor, holding the fact that electricity is non-excisable is no ground to deny the credit. That portion of the order of the commissioner is not challenged was not challenged the department before the tribunal as attained finality. Page 62, paragraph 20. Page 20, paragraph minutes would be para 6.0. What minutes?
1.
Para 6.0, page 62, internal page 20. Regarding the allegation raised in paragraph 2.3 above, that SENVAT credit will not be available since power is non-excisable commodity, I find such a contention as no legal force. As rightly pointed out by KMCL in their written submissions, the fact that power is non-excisable commodity is irrelevant while considering admissibility of the credit on the inputs and capital goods used in the manufacture of final product which are excisable. Power is being generated at the intermediate stage and consumed in the manufacture of final product which are excisable. No such contention is maintainable. Hence,
it's not used in the manufacture of the final product, because what you're trying to say is capital goods you only have to show it is being used in the factory,
Yes, my lords.
not for the purpose of manufacture.
Manufacturer, yes, yes.
But here the commissioner seems to think this has gone into the manufacture of final products.
Ultimately, that is the fact also. Man. It's a fact that it has gone into the manufacturer. And this part of the order, the department is not challenged. This finding of the commissioner is not challenged by the department in the appeal before tribunal.
No, but factually during this period, there's no question of a final product.
Even then, I have to take a registration. I am a manufacturer Coke.
No, intention, what you do in future is one thing.
Correct.
That's why the period becomes important. Isn't it?
I'll just point out. That's what when my learned friend read 174 also. Any person who engages in the manufacture of final products is supposed to take registration. So when I set up the plant and their own circular says that I have to take registration when I am intention of setting up the manufacturing premises. So when I set up the power plant or the entire manufacturing facility, when I am going to procure capital goods and it's going to take say 3 or 4 years for the erection or complete commissioning of the power plant. On the first day itself, I am required to take registration. So which I have done, which also as superintendent has also given me a registration. Once I take registration, I am required to comply with the requirements of filing the returns, etc. Nil returns I will file. During that earlier period of the RT12 returns, thereafter it became ER1 returns. I was filing nil return. So as and when I keep getting the goods, I am entitled to take credit, which lies in my books. I file my return also saying credit is taken lying in my books. That is the period when I have taken the credit. Ultimately, when I commence commercial production, when I clear excisable goods out of my factory, I am required to, I utilize this credit. So therefore, the period, we do consider that 2000, March 2001 to June 2001, nothing is happening. Therefore, credit may not be a ground because I have a manufacturer who has taken registration, who is entitled to take credit on receipt. And therefore, in fact, if it was a period prior to April 2000, as I pointed out, I could not have taken credit till I install the capital goods in the factory. And I had to give a declaration to the range officer to say, I have installed the credit and I have to give a declaration under Rule 57T3. So that was not required from 1st April 2000. And that's the period when the goods came in, I have taken credit also. Therefore, fact that I subsequently am a manufacturer, no doubt on that fact. Fact I am manufacturing dutiable goods, no doubt on it. Assuming a case, my lords, I took credit in March 2001 to set up the electricity power plant and also this coke oven. Assuming coke was exempt, I would not have been eligible for credit also in the first place because it is used for manufacture of coke at the time of receipt, etc. It was an exempted product. Therefore, no credit could have been taken. I would have fallen within the exclusion under Rule 5783. Because coke is dutiable, I am eligible to take credit. In fact, if coke was exempt, I was not even required to take registration because I am not manufacturing any dutiable excisable goods. Therefore, my lords, March 2001 to June 2001, credit valid taken because I was registered SSC. Capital goods came in, I was entitled to take credit, I have taken credit. Utilization of this credit happened only when I manufactured coke and cleared, which happened subsequently. Because the requirement is in the factory of the manufacturer.
All right.
That's the only equation. And that is what. There is a circular of 1994, which in my written note I have given. There is a circular of 26th of December 94.
It says what?
I'll just read this para 2 of the circular. This entire circular is in the context of the stage of initiating whether credit can be utilized, availed, etc. The issue has been examined. I'll just read this full circular. The board is in receipt of references from field formation to amend Rule 174 and the rules under section AAA of the chapter 5 of central excise rule so that moderate credit should be allowed on receipt of capital goods during setting up of the factory for manufacture of final products. It has been stated that in these cases, difficulty is experienced because initial setting up of the factory as such may not be physically in existence and that it may take several years before the factory is fully manufacture of final products. The issue has been examined. It is observed that credit of duty paid on capital goods is admissible only when such capital goods enter into production. Therefore, it will not be appropriate to allow the credit at the stage of initial setting up of the factory where the factory is not in existence. The manufacturer intending to take credit of the duty paid on capital goods in such a case shall continue to file a declaration as required under Rule 57Q, irrespective of the fact that such factory has come into existence or got registered. The credit on capital goods received at the time of establishment of such a factory can be availed only after the factory commences production and is registered. This because at that relevant point, the rule for capital goods said credit can be taken only after installation. And the circular was of 1994. This is one of the contemporaneous circular issued in 1994 because from 1st April 94, credit on capital goods were allowed for the first time under the Morvat scheme. And it says the credit so availed can be utilized for payment of duty on goods manufactured or cleared by such factory. And that's the precise reason from 1st April 2000, they took away that exclusion of taking credit of installation, etc. The only requirement of capital goods received in the factory of the manufacturer, take credit 50% in the first year, 50% in the subsequent year. Continue till the GST law came in, and then thereafter, my lords, they have made it as one single credit now also.
All right. All right. We'll reserve orders. Orders reserved.
Obliged. Great. Deeply obliged.
Supplementary list, old matter, item number 2.
No, please.
Supplementary list, item number 3.
Item number 3, my lord. You have complied your lordship's order dated 27/9, my lord. I am filed an affidavit, my lord. I am serving a copy on my lord friend, my lord.
Yes. What's the affidavit? Where is the affidavit?
My lord,
Where is your affidavit, please?
affidavit I filed on 20/10/2022, my lord.
What have you said there?
I have already complied your lordship's order, my lord. And payment has been made in due compliance of your lordship's order.
You received the payment.
My lord,
Yes, madam.
All right.
I have served a copy, my lord.
All right.
Only I pray, my lord. Your lordship may list it on next week any day, my lord, for hearing, my lord. Mr. Senior Counsel is appearing in my matter.
An affidavit dated 14/10/2022 has been filed by the LIC confirming payment of the sum of rupees 10,48,000 to the respondent, which is acknowledged by counsel to the respondent. Paragraph. At the request of counsel to the appellant, who states that the list on 1st February.
First, my lord.
1st February. Item number 4.
None appears dismissed.
Item number
My lord, I am for the respondent number 6, my lord. I have filed a caveat petition.
All right. None appears. This is an opposition.
item number 6.
Your Lordship, I am appearing for the appellant's India Tourism Development Corporation. Your Lordship, senior counsel is in some personal inconvenience as he is being out of town. Item number 6, Your Lordship.
Who are you, please?
Manager Legal Gaurav Sharma from India Tourism Development Corporation, Your Lordship. Appellant side, Your Lordship.
I am for the respondent's lordships.
And Your Lordship, main matter which is arising out of the common judgment registered on 21st November. So it is humbly requested the matter may be posted on 21 or any date as may be convenient to the Honorable Court, Your Lordship.
All right. The manager legal of the appellant appears virtually. and states that the council is in some difficulty today. 21st November, is it?
Yes, Lordships, the main matter is posted.
List on 21st November.
Oblige, Your Lordship.
Item number 7.
And for the appellant, here the noting is that the person has died. So we'll take steps for substitution, right?
Notice to respond one has been returned undelivered with the report single quotes dead. Steps be taken to bring the legal representatives of respondent 9 on record.
On behalf of Mr. H.N. Mahapatra, again, respondent 9 has been died, my lord.
List on 21st February.
Item number 8.
Obliged, my lord.
Number 8.
8 I am for the respondent.
None appears for the appellant. Dismissed. On our process.
Item number 9.
None appears dismissed. On our process.
My lord, item number 8. I am for CHSE. My presence be noted.
Item number 10.
None
My
appears.
lord, my lord, item number 10.
Yes, please.
I am for the appellant, my lord. My lord, today I am ill, my lord. I could not able to go to attend. My lord,
The appellant states that he is unwell. List on
Lordship,
22nd February.
yes, other 2 matters are similar matter. Let those 2 matters may be listed along with this. I'm giving the number 226, 227, 2019.
All right, list along with.
Item number 11.
None appears dismissed. No discussion.
Item number 12.
None appears dismissed. No discussion.
Item number 13.
Item number 13, Lordship. My senior is on his legs, Lordship. Kindly adjourn the matter to some other day.
No, pass over.
Okay, sir.
Pass. Item number 14.
None appears dismissed. No discussion.
Item number 15.
None appears dismissed. No discussion.
Item number 16.
None appears dismissed. No discussion.
Item number 17.
None appears dismissed. No discussion.
Item number 18.
None appears dismissed. No discussion.
Item number 19.
19 I am respondent number 1 to 3.
None appears dismissed. No discussion.
Item number 20.
None appears dismissed. No discussion.
Item number 21.
None appears dismissed. No discussion.
Item number 22.
None appears dismissed. No discussion.
Press admission item number 23.
None appears dismissed.
Item number 24.
None appears dismissed.
Item number 25.
None appears dismissed.
Item number 26.
None appears dismissed.
No, my lord, I am from the opposite party.
All right.
I am for the opposite.
All right.
Item number 27.
None appears dismissed.
Item number 28.
May I please, Lordships?
Yes.
Lordships, I have challenged the first appeal order, which was passed ex parte without considering my written submission. At page 33, I have already disclosed that already I have paid the disputed amount in the respective returns. And in spite of my prayer that for a personal hearing, I was not heard. And my limited prayer before Lordships that let them verify the returns at least.
Who's for the other side?
I am for the opposite party.
All right. Notice, he accepts notice for the opposite parties and seeks time for instructions. Reply, if any, be filed within 4 weeks, rejoined up for the next date. February.
My interim application before your lordships. I may be protected, your lordships.
Till the next date, no coercive action shall be taken against the petition. All right.
Don't.
My lord. The petitioner challenges the virus of clause I of sub-rule 1 of rule 42 of the GST rules, my lords, wherein it is decided to determine the attributable amount of ITC available, ITC for reversal of the credit, your lordships, in terms of section 17(2) of the GST Act, your lordships. My lords, the petitioner is a manufacturer of rice bran oil from the inputs rice bran. Both the rice bran and rice bran oils are subject to GST at 8%. So during the manufacture of rice bran oil, my lord,
all you've got is a show cause notice. Why should you not reply to the show cause notice?
My lord, I challenge the virus of the rules of.
That's all right. We can reserve that challenge. If you still do not succeed, then at that stage, when you challenge the adjudication order, we'll entertain your plea.
My lord, kind of to grant the show cause notice, your lordship. Page 7 of the show cause notice, internal page 7, your lordships.
Yes.
And the running page, your lordship, page 68, my lord.
Yes.
The last part 1 para, your lordships.
Yes.
For both, may I read out to your lordship? For both rule 42(1) and rule 43(1), E is the aggregate value of exempt supply made during the period, and F is the total turnover in the state of the registered person during the on conjoint reading of rule 42(1) and 43(1) and section 2112, turnover in state and turnover in union territory.
You had to file your reply to the show cause notice by which date?
It was given, my lord, on the date has already been lapsed, my lord.
Sorry?
The date has been over, my lord.
Then?
I have challenged the show cause notice itself because the show cause notice has been, your lordships.
No. What was the date? What was the date by which you had to file the reply?
My lord, I'm coming to that, my lord. The show cause notice was dated 4th of August 22, your lordships.
6th of August, sir.
4th, sorry, it may be
19th August.
62, your lordships.
62. 4th August. All right.
My lord.
What is by which date?
By 19th of 19th of August 22, my lord.
So you did not file this writ petition before that date.
But I have filed the writ petition already in the month of 8th of September, my lord.
That's right. So long after the date, deadline also got over.
Not much beyond your lordship. With
No.
limits, my lord.
No. There's no need for for us to grant you this kind of indulgence, sir.
My submission is that the learned.
If you are so interested, if the adjudication order has not yet been passed, then we can extend the time for you to file reply, reserving all your pleas on this, whatever you've raised in the petition, to be raised at the appropriate stage. Otherwise, we are not inclined to entertain, sir.
Including the virus of your lordship.
At the show cause notice stage, we are not inclined to entertain.
The virus may be kindly considered by the adjudicating authority, your lordship, because he already formed.
He cannot consider the virus, sir. How can he consider the virus? We'll reserve your right to raise it at the appropriate stage. You see,
because he's already been formed opinion, my lord, already.
So this is only a show cause notice. All show cause notices do set out what they consider to be a prima facie opinion.
But this has been the word has been incorporated.
Anyway, sir, we are not inclined to entertain, sir. It's up to you. If you insist only on arguing, it's the detailed order.
I may give. I allowed to appeal before authority.
All right. You say, counsel for the petitioner seeks leave to withdraw the present petition.
No, I am appearing on their department.
All right. Seeking leave to urge all the pleas raised in the present petition, including challenging the virus.
No, please. No, please. No, not when.
Where have you challenged the virus? Just see this. Let's see the praise in your writ petition. Have you challenged the virus?
My lord.
Where have you done that?
Yes, my lord.
I see, including the challenge to the virus of Rule 42 bracket 1 bracket small I and 43 bracket 1 bracket G of the OGST oblique SGST rules to be urged at the appropriate stage. Stop. This post office withdrawn with liberty is prayed for in the above terms.
Item number 30.
May I be pardoned, your lordship? Item 26.
Respond number 4, Central GST, my lords.
All right. Yes, item 26.
Item 26, your lordship, we have filed a memo stating that as per the Supreme Court order in SLP number 320 of 2018, our matter is covered.
All right.
So appropriate orders may be passed according to.
What does that mean?
I have attached.
May I be permitted, my lord, to submit, my lord? I'm sorry, my lord, I'm appearing on VC.
Yes.
My lord, in this case, though I have challenged the order of the learned commissioner, rejecting my representation, but the issue involved is with regard to filing of Tran 1 and Tran 2 form for transitional credit, my lord.
Right.
Now, during pendency of this writ petition, my lord, several matters were before the Honorable Supreme Court, and I have filed a memo to that effect. And pursuant to the orders of this Honorable Supreme Court, the online portal, in the present case, the 8 is the GST this network, wherein the Honorable Supreme Court has directed GSTN to open the portal and allow to file, upload the Tran 1, Tran 2 form, as well as to revise the returns if any.
You have already done that?
My lord, date is now, it is pending, my lord. It is continuing. I will be doing that, my lord, in the meantime.
All right. Counsel for the learned counsel for the petitioner states that pursuant to the order passed by the Supreme Court of India on 22nd July 2022 in
I'm sorry, my lord. Pursuant to this order of the Supreme Court, my lord, the Principal Commissioner GST has also issued a guidelines circular giving a guideline to how to proceed ahead with the filing and all. All that also I have annexed.
All right. 32709-10 of 2018 bracket Union of India versus Philco Trade Center Private Limited bracket. The Principal Commissioner bracket GST issued a circular dated 9th September 2022 issuing guidelines for filing revising Tran 1 Tran 2. Stop. Counsel for the petitioner states that the petitioner in the present case would be availing of the above facility and accordingly is not pressing for the relief at this stage. Disposed of is not pressed in the above terms.
Much obliged. Much obliged.
Item number 30.
Lordship, item number 30 and item number 75 are covered by your lordship's order. It's regarding demand raised on audit objection.
Audit objection.
I'm providing a copy of the order.
How they do.
Yes. All right. Same names. All right. 30 and 75.
75 and 30.
All right.
Item 31.
My lord, in this matter, my lord, opinion number 5 for on-soft license has already been rejected by the government. Being agreed, he has filed a separate application. In view of this, my case has become infructuous.
All right. Counsel for the petitioner states that due to subsequent developments, the petition has been rendered infructuous. It is
I am appearing for the opinion number 5.
All right.
Caveater.
All right.
Item number 32.
Pass over.
Item number 33.
On behalf of Mr. Chand, my lord, kindly be matter kindly be taken next week, my lord.
Why?
Mr. Chand is out of station.
It's a fresh matter, sir.
Look, this is a demand against shortfall MGQ. They
Ah.
may approach the excise commissioner against the order of the.
They can, you know.
collector. Yes, they
Ah.
can go.
Or against the impugned demand of shortfall of NGQ. An appeal is provided, is it?
Yes.
To the excise commissioner under?
Excise commissioner Odisha.
Under which rule?
249, I think.
Under rule 249 of the?
I'm sorry, 251. 251 of the Odisha Excise Rules 2017.
Right. Orissa Excise Rules 2017, permitting the appellant to avail of the said remedy. The court declines to interfere at this stage. The petition is disposed.
Item number 34.
On item 34, not here I have challenged the demand notice, but subsequently another demand notice is issued, which was challenged before the commissioner, and commissioner has rejected. Now I have filed revision before the government. Now government it is pending. So
So it
virtually
is
not
in
a-
progress.
it does
All right.
subsequent development.
Petitioner states
Subsequent
that
development.
subsequent events, the present petition has been rendered infructuous and it is disposed of as such.
Item number 35.
None appears dismissed.
Item number 36.
None appears dismissed. The contempt petition is also disposed of.
There is a contempt petition.
Yeah, that's disposed of.
Item number 37.
Lordship, on item 37, I appear for the revision petitioner number 1. He has passed away in the meantime, so no instructions are covered.
Yeah, no instructions dismissed. All right.
Item 38.
That reviews.
Yeah, no ground dismissed. Same 39 also.
39.
Yeah, same.
Item number 40.
None appears dismissed.
Item 41.
Same order.
Both the cases, I am for the opposite party.
All right, sir.
Item 42.
None appears dismissed.
Item number 43.
None appears dismissed.
Item number 44.
None appears dismissed.
Item number 45. Item number 46.
None appears dismissed.
Item number 47.
I am for the appellant.
We'll just pass it over once, just see what happens.
Item number 48.
This matter, my lords, I just pray for 2 weeks' time to cure the defects, my lords.
All right.
Because Annexure 5 has wrongly been filed for some other case, my lords.
All right. You see, counsel for the petitioners and is granted 2 weeks' time to do defects. List thereafter.
Item 49.
49, my lords, I'll be serving you an extra copy that will take care of the first defect. The second defect, my lord, is that the reference certificate. I've mentioned the connected writ application, but I've just not mentioned that it is pending before your lordships. So your lordship may kindly ignore that defect and list it on 11th of November.
All right. A
Allow
copy
me-
of the petition is stated to have been served.
I'll serve it in course of the day.
Well, counsel for the petitioner states that a copy will be served on counsel of the state during the course of the day.
And the other defect may kindly be ignored.
The other was 17 being ignored.
Subject to your lordship kind convenience, similar matters are being listed on the 11th of this month. my lords.
All right. List on 11th November. All right.
Item number 50.
50 again, 2 weeks' time, my lord, for Annexure 1 certified copy.
Same order as in 48.
48, my lords.
All right.
Item number 51.
51, my lords, again, my lords, I'll serve a copy in course of the day. And your lordship may kindly ignore 17 because
All right.
again, the
Same as 49.
49 and it may be listed on 11th.
11th, yes.
Item number 52.
52, my lords, will be listed on the 11th. In the course of the day, I'll file a copy, my lords.
Same as in 50.
Item 53.
53, my lords, 2 weeks' time, I kindly grant it. my lords.
Same as in 49.
Item number 54.
None appears dismissed.
Item number 55.
None appears dismissed.
Item number 56.
Madam,
56, 57 and 58 millers, I bring 2 weeks time to remove the defects millers.
Defects be removed within 2 weeks is the last opportunity. List thereafter.
I am appealing for the opposite party. In all the cases. 6, 57, 58.
Item 59.
May I please, Your Lords? In this matter, this is a covered matter as per Your Lordship decision. Next report, page 15, my Lord. I am not able to file my return due to closure of the portal, my Lord. And now we agree to make payment of the whatever the dues with us. Let the portal will be open.
Same order. Who's there for the other side? Mr. Chimanka, are you there?
Yes, I am here, sir.
Same order can be passed.
Yes, my lord.
All right. Same order. As in page 15, annexure 4. All right. This. Right.
So far as the other matters concerned, there is a tax.
Sorry?
Sorry.
Item number 60.
60, my lord, I've already served a copy. Subject to your lordship's kind consideration, my lord, may I just place the matter? It's a second appeal stay, my lords. Here, my lords, it's an entry tax matter, my lords. The petitioner, my lord, is a goldsmith. And his entire case, my lord, is that these gold ornaments were purchased and sold within the local area, my lord. However, my lords, proceeding under section 10 of the OET Act, a demand was raised, my lords. I filed a first appeal and the first appeal was confirmed. Then I filed a second appeal and the matter is pending before the tribunal. During the pendency of the tribunal, I moved an application for stay of the demand, my lord, before the learned commissioner, my lords. The learned commissioner, my lord, he rejects my entire stay application and says, my lord, just because no one could appear on the VC, my lords, he paid the entire tax amount, my lord. In this case, my lord, out of the total demand, I have already paid 20% during the pendency of the first appeal as a So the total demand, my lord, is 31,76,646. Your lordship would get it at page 20.
10 more percent. I think that should suffice. All right.
10 more percent of the remaining amount, because I've already paid 20.
My lord, may I pray? Tax amount will be.
Lordship, my entire case, my lord, but my subsequent case also, my lord, that the section 10 application, order cannot sustain in view of your lordship's and ECMAR case, my lords.
Right.
I'll take that ground before the tribunal, my lords. Prima facie has a good case.
All right. The challenge in the present petition is to an order dated 4 January 2022 of the Commissioner of Sales Tax Orissa, rejecting by the petitioner, pending the disposal of the second appeal by the tribunal. Is it? Paragraph. At the outset, Mr. Kara, learned counsel appearing for the petitioner, points out that of the demanded tax amount of 31,76,646, the petitioner had already deposited 20%.
20% as a pre-deposit during the first appeal.
At the first appeal stage, full stop. Paragraph. Having heard learned counsel to the parties and considering that the impugn order was passed virtually without the participation of the and was disposed of single courts ex parte, it is directed that subject to the petitioner depositing a further amount constituting 10% of the balance tax amount, there will be no further coercive steps taken within a period of 4 weeks from today. No coercive steps will be taken against the petitioner during the pendency of the second appeal.
Greatly obliged.
This order will be in substitution of the impugned order of the commissioner. The petition is disposed of.
Much obliged.
Item number 61.
I beg your please, item number 54.
54 is gone away, sir. You will have to wait.
Dismissed for default. In fact, it is forwarded and dismissed by your lordship. The prayer is otherwise required to be dismissed by virtue of the lordship's order.
All right. All right.
My lord, item 60.
Swine and Company.
My lord, that's the reimbursement of GST. Your lordship have already passed an order dismissing that.
In view of the judgment of this court, in Harish Chandra Maji versus State of Orissa, 2021, 93 GSTR 3554, the present petition is dismissed. All right.
My lord, I am appearing.
All right, sir.
Item 61.
My lord, I will rectify the defects, your lordship. I may be matter may be listed in the next week, my lord.
Defects be removed within a week. Thereafter.
Item 62.
See, so the defect will rectify by next week, my lord.
All right. Defects be removed within a week. List thereafter.
Item 63.
Item 63, let's say I may be permitted to remove the defects by next week, let's say.
All right. Same order. 63.
Okay.
Item 64.
64, my lord, I'll be serving a copy in course of the day. The second defect, my lord, can be ignored because the names in capital letters have not been mentioned in the wakalat.
All right.
And this matter may be taken up on the 11th of this month. This is the entry tax interest matter.
All right. You say counsel for the petitioners. This copy of the petition will be served on counsel for this department during the course of the day. Then you say defect 7 bracket 2 be ignored. List on 11th.
11.
Item number 65.
Item 65 will rectify the defects within a week's time.
All right. Defects be rectified within a week. List thereafter.
Item number 66.
66, my lord, I humbly pray your lordship may kindly ignore the defect. That's only instead of paragraph 6 and 7, it has been mentioned in 5 and 6, my lords. Here the matter, my lord, is my first appeal has been rejected under the GST Act. Summarily, I have, in absence of a tribunal, my lords.
Right. Since there is, you say, considering that there is no second appellate tribunal to consider the impugned correctness of the impugned order, the present petition has been filed.
I beg your pardon, this is summary rejected.
This is summary rejected.
Summary rejection.
Summary rejected. The present petition is entertained. Notice, he accepts notice. Reply be filed within 4 weeks, rejoined up for the next date.
So I was simply praying, Lord, I've already paid 10%.
10 more percent.
20% of the more percent of the remaining
subject to the petitioner paying a further 10% of the remaining tax amount within a period of 4 weeks. No coercive steps will be taken against the petitioner during the pendency of the petition. This IA disposed of.
Much obliged.
List on 22nd February.
Obliged.
Item 67.
May I please, lordships. Your lordships, here also I have challenged the first appeal order where entire tax amount has been deposited by the annexer 4 series, your lordships.
There are so many defects, but several defects.
So that
I think you'll remove the defects and I'll take it up after that. Defects will be removed within a week. Yeah, list thereafter. Right.
Item number 68.
May it please your lordships.
Defect is not serving a copy.
Not necessary, my lords. How can I give the copy? Mr. Chimanka is always appearing in BC, though there is no corona restriction. And my lords, he is asking for fees. Here, my lords. Here, my lords.
No,
here, I see not needed because I am going to withdraw. Your name will be recorded and you will also get the fees. As I have pocketed the fees myself, I found that it will be too stress to stress the writ jurisdiction.
I see.
I remember the case of Sunil Batra versus Delhi administration. Our writ will run through the iron walls. So in that first impression, I accepted the brief and pocketed the fees. So what I pray, my lords,
yes,
limited prayer is that if any cause of action within the territorial jurisdiction of this honorable court, my lords, then I may be permitted to approach your lords.
All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to file a fresh petition if any cause of action arises within the territorial jurisdiction of this court.
Of this honorable.
Right. Disposed of is withdrawn.
I am giving copy. I am giving copy. Don't worry. I am giving. Yes, definitely. Sorry.
No, I'm sorry.
How copy da de diyantu. And another copy I could have given to Chimanta. Both of them would have, but he is in this BC. Why he is not coming out? I don't know.
Not issue here. Don't use money.
Put my pen in the right hand, my lord. I'm not good. Pain in the right hand.
Okay. But you are day by day getting younger. Oblige, man.
All right.
Item number 69.
May be permitted to prefer defect removal.
All right. Defects be removed within a week. List thereafter.
Item number 70.
70, your lordships, I have challenged the first appeal order. I have deposited 10% because of the lack of appellate tribunal.
All right. You say the same order.
Copy not, sir.
Yes, it is served. I have the receipt also.
Same order as in Mr. Karan.
Give an extra copy, madam.
I'll serve the extra one by tomorrow, your lordship.
This is item number. Right now it's 71, right?
71.
70. Same order as in, I think 66, right? 66, 10%. Yeah. Same order as in 66. All right. No coercive steps, same date, 22nd February. Right. All right.
Item
71 and 86, your lordships, 3 are RC revocation matters. I have annexed your lordship's order, and after that also.
Your Honor, on behalf of the department, 86 number.
86, no.
This can be covered. This is covered by the.
It's covered by the Honorable High Court.
All right. Same order as in Annex 3.
In 71, I am appearing.
All right.
71 and 86, your lordships.
All right. Same orders.
My name may be recorded in
Or
86.
All right.
Item number 72.
Your lordship, I am on behalf of Mr. Acharya, lordship. Mr. Acharya is having health issues, your lordship. So if your lordship may kindly hear this matter next week.
All right. Mr. Acharya is stated to be unwell. List on. November.
Highly obliged, your lordship.
Number 73.
Pass it.
Item number 74.
My lord, I am Sandeep Acharya. My advocate is not here.
We have passed over, sir. Ask him to come.
73.
Ask him to come, sir. We have passed over.
Item number 74.
Item 74, Lordships, we are challenging the settlement of liquor shop through lottery. Lordships have already.
In view of the judgment in Navin Kumar, the present petition is dismissed.
Item number 76.
Pass over.
Item number 77.
Pass over.
Item number 78.
In the item 78, here it is a for grant of license, but the matter is pending before the government. My second prayer is with regard to Lord for pending before the government pursuant to the recommendation under Annex 4 of the collector. That may be not considered as per Rule 51 of the Odisha Excise Rules.
All right.
Annex 4, page 19 is the collector has submitted the proposal to the government for consideration. Last 2 lines. Hence, the proposal may be sent to government in excise department for non-consideration as proposal by the collector Cuttack.
What is the excise commission?
Now it is pending before the government. The 7th of this month has been fixed for hearing.
So what do you want to do then?
Lordship may dispose of with that government will consider the recommendation.
Mr. Patra informs the court that the date for considering the recommendation of the collector by the government is 7th of November 2022. Utsapi accordingly seeks leave to withdraw the present petition with liberty to challenge the said decision if it is adverse to the petition. Disposed of.
Already challenged. No, it is already challenged and date has been fixed for hearing on. So he should decide.
True, sir, but that decision you may want to challenge if it goes against you.
Yes, no, that will challenge before your lordship.
That's
before
what.
Yes.
That's why we're not entertaining the present. Yeah.
Yes. Just the Lordship said that let the government may decide in accordance with law.
That obviously
That is, all these observations will.
Yeah.
Item number 79.
None appears dismissed. The contempt petition is disposed of. None appears.
Item number 80. Item number 80.
Maybe adjourn to any other date because it's a very important matter.
Underpass.
Yes, providing underpass.
List on. In January.
My lord.
16 January.
16th January.
Item 18. Item 80.
Item number 81.
You have to file an affidavit. What happened?
I've already filed it.
I see. All right.
I've already filed an
You say
affidavit.
the affidavit of NHAI is on record. List on 16 January. All right.
Item number 81.
Buttons, I think. Katkia wanted time for instructions on this last time.
81. My lord, may kindly pass over. My lord, may kindly pass over this.
All right, pass over.
Item number 83. Item number 83.
None appears on the previous date or none appears for the petition today as well. Dismiss for non-prosecution.
Item number 84.
In item 84, Your Lordship on the last occasion had directed the state counsel for the department, the commercial tax department, to give the details of the revisions filed in this regard.
We need some time.
The department needs more time to comply with the order dated 20th July 2022. That is request list on. (16 January).
As Your Lordship is deeply appreciated.
Item number 85.
May it please Your Lordship.
Yeah.
Well, there's 85. I pray Your Lordship of the rejoinder.
All right. Rejoinder will be filed for the next date. Is there an interim order?
It is an interim order to continue.
Yeah, interim order to continue. 16 January.
Matter. The second matter, just a minute. Second matter that, sorry. Yes.
230867, the fourth number, I will be filing counter on that.
All right. 23067, you say counsel for the state seeks and is granted 4 weeks time for counter rejoinder for the next date, same date.
My lords, for fee grade and Bonai, my lords, I am appearing for petitioner.
Yes.
So far as read petition number 5278 of 2022, I have already filed the counter, my lord.
All right.
Not we have been served the copy today itself.
All right. Rejoined to be filed for the next date. All right.
And
Interim order to continue, please.
and
Yeah, interim order
WPC
to
9841 of 2022, I'll be filing a comment.
All right. In 9841, you say counsel to the department seeks and is granted 4 weeks to file reply rejoined for the next date. Again, listed the same date, interim orders to cut. Right.
Oblige you not.
Item number 87.
No, my lords, this is another left out. 2367. Here, just a minute. Here, my lordship have not admitted the application. Only notice has been.
No, but he sought time in this only.
No, he sought time in this
23067 only.
2307.
Oh, it is
2307. 23067.
He sought time in that only.
Well, it has not been admitted.
Anyway, he said notice, then he accepts
Notice has been issued. What I pray, my lords, lords may admit this application and keep it to 16th of January along with this.
Correct. It's already there, sir.
Yes. Interim order to continue, my lords.
Yeah. Interim order.
Much obliged, my lords.
Supplementary list item number 87.
But 87 to 90 are covered matters. I have given lordship's order where, my lord, the shops were closed on account of an government land and shop not operation, and for that period demand notice has been issued. I have given, lord, to the court master. Lordship's order is there.
All right. Same order.
All 4 matters same.
Only the facts will have to be changed. Dates.
Yes, up to 90, my lord. All
Yes.
Pastor matter item number 13.
Despite Passover. None appears. Dismissed.
Item number 32.
Despite Passover, none appears. Dismissed.
Item number 47. Item 47.
The appellant was present at the first call. Counsel, the appellant was present at the first call. Today, you say in terms of the order dated 10th October 2022, the respondent was directed to remain present in this court with the balance sum of 45,000. How full stop, however, is not present. A bailable warrant be issued through the SHO of the concerned police station, requiring the respondent to remain present on the next day and to comply with the direction already issued on 10th October 2022. A copy of this order will be immediately delivered to the SHO along with the production warrant. List on December.
Item number 73.
None appears despite Passover. 73 he was present.
Appellant. I am for the appellant, 47.
No, that I have noted. So we've kept it for 8th December. I've issued a bailable warrant for his appearance.
73.
You are appearing 73?
No.
73, you see, petitioner in person, the petitioner was appearing in person on the first call. On the second call, there is none appearing. This is a non-prosecution.
Item number 76.
No, petitioner appeared in person and sought a Passover. On the second call, none appears. This was a non-prosecution.
Item number 76.
None appears despite a pass over. Dismissed.
Item number 77.
This is the demand notice issued by the district office. So they have to prefer appeal against. Annex
All right.
2 is the demand notice.
All right. Permitting the petitioner to avail of the remedy of a statutory appeal against the impugned demand notice. The petition is disposed of.
Item number 81.
Number 77, there are two items.
77?
No, my lord. I'm sorry. The only one.
Item 81.
Katkia was to obtain instructions. What happened?
Lord, my lord, maybe kindly adjourn it. Tomorrow we'll see.
The AGS states that some will be granted for instructions. List on 4th January, interim order to continue. 2 o'clock. All right. We come back at 2 o'clock.
honorable court, the opposite party has deposited a check of rupees 9 lakhs some odd in this court. And they are also agreed to pay the other gratuity and pensionary benefit to the petitioner.
All right.
In accordance with law. The lordship may
Subject to he had fulfilled the forms, my lord. That is, some formats are there for getting the pension and other retirement benefits.
Right. You see, this is an application. By the petitioner seeking recall of the order dated 9th May 2022 in contempt case number 2173 of 2012 and for a direction to the opposite party management to deposit the revalidated check of rupees 936,387. Which had earlier been deposited, but was unable to be encashed because of the stay order in the writ appeal number 593, 621 and 622 of 2011. Paragraph. It may be noted that all three writ appeals have since been dismissed on 9th May 2011.
Yes,
2011.
Delay.
142.
On the ground of delay. Full stop. Paragraph. In view of the above developments, the order dated 9th May 2022 is recalled and contempt case number 2173 of 2012 is restored to file. And then in contempt case number 2173 of 2012, Counsel for the Management states that the revalidated check of rupees 936,387 will now be directly handed over.
Yes, already deposited before the annual court. That has been annexed to it.
Oh, in this court, full stop. This is in favor of whom?
On behalf of the petitioner.
The said check will now be released by the registry to the petitioner upon proper identification. Full stop. Anything more needs to be said?
No. That is with regard to retirement benefits, my lord. If you will
As regards the other retirement benefits of the petitioner, Counsel for the Management states that if he approaches the management and complies with all the formalities, the amounts will be released to him without delay. The case is disposed of in the evidence.
Seek your lordship permission to make a mention. Lord, on item number 13.
Not
38.
Item number 13, my lord. 1-3. In fact, it was passed over on my prayer. By the time it was recalled, in fact, I was on my legs in some other court, my lord. I could not reach your lordship.
Okay.
So,
You can take it up now.
Lord, I am otherwise ready.
Let's
But
take it up right away. Because same bench only.
Item 13.
13. My lordship says I am challenging the order passed by the Honorable Single Judge. My lord, in exercise of power under the Odisha Constitution Act and rules, my lord.
Right.
The petitioners, they represented one branch, and if your lordship sees, by virtue of a mutual understanding and one particular document, the property was recorded entirely in favor of one branch. That is our branch. Now, during consultation, they filed objection and the property got recorded. Of course, in the settlement, the property got jointly recorded. This consultation.
You should notice. Notice doesn't seem to have gone so far. No notice so far.
Your lordship, please, madam.
Just say notice returnable. February.
I'm grateful, my lord.
Not
Item number 82, sir.
The item 82, my lords. Which involve identical issue, identical assessing, and the opposite parties are also same. My lord, this is covered by your lordship's order of the same petitioner.
Okay.
And the opposite party is also same.
All right.
And the counsel for both the parties are same.
Okay.
Your lordship.
There the issue is, just a minute. Issue is whether coal can be set off. That your lordship sitting with Justice B.P. Raut decided the favor of the assessee.
Coal is not a raw material.
There, yes.
I am agreed to that issue. Your lordship may kindly turn to the prayer of the writ petition. So let him restrict to prayer number 2 only. Prayer number 1 and 3, he may not press.
9515.
Your lordship, 141516, 3 matters.
Right, 1415 and
14, your lordship.
All right,
14 may kindly look into prayer 15, page 15.
Right.
3 prayers are there.
Right.
The first one is
16 na? Page 16.
First one does not survive.
First one does not survive.
Yeah.
He will not praise. And prayer number, because in the assessment order, along with this raw material addition, some other additions are there.
No, I am restricting only to the set of is concerned.
Clarify.
So let the assessing officer recalculate it after giving the setup. That is my prayer.
Correct.
And only prayer number 2
is
covered by this.
Correct. You say in these 3 petitions, Mr. Siddharth Rai, learned counsel the petitioner. Presses only for prayer 2, namely open petition. Shall not be allowed to claim set-off of entry tax paid on purchase of coal against entry tax payable on sale of its finished product. Question mark unquote. Full stop. The said question is covered in favor of the petitioner by the decision of this court in Associated Cement Companies Limited versus State of Orissa, AAR 2022 Orissa 11. Stop. This is not disputed by learned counsel for the department. Mr. Sunil Mishra, learned additional standing counsel for the department. Paragraph. Consequently, the petition is disposed of by granting only the relief as far as prayer 2 and by allowing the prayer in terms of the aforementioned judgment of this court. Paragraph. As regards prayer 3, it will be open to the assessing officer now to recompute the tax demand on the basis of the present order.
Your lordship may kindly note that the petitioner does not praise prayer number 1.
Yeah. And the officer says he does not press for prayer 1 and only presses for prayer 2. All right.
You will not leave me. Another
It's already decided was
7.5. I think that is a tag with a lead case. So that matter of the petitioner may be hard.
Which one? 9515?
No, my lord. That is 7975 of 2011.
No. This order covers all three, no?
Yes. All. 9514, 9515
and 9516.
9516.
Now we'll call from the first now.
Yes.
Your Lordship.
Milords, may I submit one thing, Milords?
Yes.
In batch of writ petitions, Milords. Milords, Your Lordship, I kindly see the second item, WPC number 6. Reliance Justice versus Assessing Authority. Milords, there are 5 writ petitions. 4 writ petitions have in the meantime been disposed of. Milords, I have taken liberty from Your Lordship to relegate the matter because assessment order was under challenge in this application. 4 written applications, Your Lordship relegated me to approach the appellate authority, Milords. And I am giving Your Lordship a copy of my Lord's order, Milords.
Right.
And in the light of that, I will pray Your Lordship to relegate me.
So this is only in 6515.
6515 only, Milords.
All right. In 6515.
Same terms, Milords.
So same order. So we'll be appearing before the appellate authority on 1st December 2022, you say?
Minor.
Instead of 1st February.
Okay.
Otherwise, it's the same, only the writ petition.
Lordship, it is remanded for appeal, for filing of appeal.
Correct.
Yes. There is one more matter. You kindly see WPC number 3562 of 2008. Rumta Mines Limited versus State Milords. This matter, Your Lordship, kindly permit me to withdraw, Milords.
Correct. Rumta Mines, counsel for the learned senior counsel for the petitioner seeks leave to withdraw the present petition. Dismissed as withdraw.
In view of that order, my lords, my writ petition also, Lordship may permit me. That is 7975. Second.
Your 7975.
7975. I'll
go to the appellate authority.
Appellate authority. Lordship may just extend the time only up to 10th of December, my lords. Sorry. Yes, 10th of December. Because, my lords, I have to.
Or in this case, it will be 10th December. 7975. Same order.
So far, this batch of writ petition concerned, my lords. As my lords know, my lords, these have all come by way of apex court to revisit on the issue.
Correct.
By permitting us to, my lords, carry out amendment. And the amendment we have permitted to take grounds and also to place materials for lordship, whether there at all occurs discrimination in terms of Article 304A of the Constitution of India.
Correct.
Pursuant to honorable direction, Milords, we have all Milords filed amendment applications. And
Sir, you have to unmute yourself, Mr. Sahu. Yes.
Am I audible, my lord?
Yes.
That's what I am humbly submitting. We are seeing all these batch of cases, my lords. In some cases, my lords, the rejoinder have been filed, though in some cases in my lords. But we will be, my lords, submitting a paper book along with all judgments and all, my lords, copies of all documents so that it can be easier for your lordship to take it up for final hearing. That is what humble submission.
Open is free, sir. All right. You say Mr. Sahu, learned counsel appearing for some of the petitioners, undertakes to file a compilation, a convenience compilation containing all the judgments that the petitioners seek to rely upon, along with a written note of submissions.
My lords.
The state is also permitted to do likewise before the next state.
Your lords.
My lords, actually, the Supreme Court order itself indicates the judgment your lordship will give.
Okay.
Your lord.
All right.
And, it is the stand of the department that central sales tax they will not take into consideration.
Okay.
They have given charts of amounts, how they are equally demanding their amount. But actually, central sales tax they have not taken. Supreme Court says that central sales tax is one of the amounts which should be taken in equalizing this. Out of 15 questions, it came to 10. From 10, it came to 4. From 4, it came to 2. And one is sent back to the appropriate bench, and the appropriate bench has sent it here.
Nice.
We have come here 3 times, 13, 11, 2000, and 17, 1, 2008, 8, 2, 2008. So the result was that no amount of tax was imposed. Subsequently, by a Supreme Court order, assessments were made and taxes have been paid.
All right.
With great respect to my learned senior, if central sales tax will be, the setup will be given to central sales tax, then there will be a complete discrimination to the indigenous dealer, and the indigenous dealer will pay more than the import dealers. I'll convince you, let's see the entire example I have and the judgments I have.
The Supreme Court has Justice Thakur's judgment, the last portion he has said, because if he takes Kathiranan's case as a model and Justice Fazal Ali's judgment as a model, discrimination is made it with purpose and without purpose. And your I have given in my chart, all the 7 illustrations you have given in your chart, I have given that they are not becoming equal.
Your Lordship, what I pray, WPC number 8889 of 2017, in case of Vedanta Aluminium Limited, that may be the lead case, that may be listed as a lead case, because Honorable Supreme Court and two judgments have been passed. Honorable Supreme Court has remanded some matter and directed them to file a writ petition appraise. And in some cases, that the old case will be revived after filing of revival. So Vedanta case may be lead case, because I will get the opportunity to argue against my senior Mr. Ganguly is coming from Delhi. So that may be the lead case, because entire pleadings have been completed in that case.
That's correct, Lordships. I appear for Vedanta, Milords. That's correct. In fact, Milords, in Vedanta's matter, Milords, there are now 3 petitions. One is a petition which is only pertaining to indigenous goods. One is a petition which is for imported goods, which was into the judgment of the Supreme Court. And third is a petition which is with respect to certain supplies made to special economic zones. Now, my lords, in Vedanta's case, the pleadings are complete. There are counters, rejoinders, sir rejoinders, everything fine. Senior Advocate Ganguly was leading this entire batch, your lordships. So if your lordships, my lords, are agreeable, that can be taken as the first matter. In that, my lords, as per the Supreme Court's declaration, an overall burden has to be shown, a comparison with respect to the burden of taxes on imported goods as with goods. We have made charts, my lords, to put that on record. In addition, your lordships, there are certain other grounds with respect to the levy being on coal, bauxite, etc., because that field, my lords, is now occupied by the union. So there are a number of issues, my lords. We prepared written submissions. We also have, my lords, judgments which we'll be placing on record. Whatever convenient.
Sir, I'm praying so, because it is an opportunity here. I'm praying so.
All right.
You
see,
you do not appear against us.
Not even great respect. Sir, great respect. Great respect.
You see, petitions agree that when the matters are called out or listed next, writ petition civil 8889 of 2017 will be treated as the lead case. All right.
Obliged.
I may be pardoned, Your Lordship.
Yes.
I may be pardoned, Your Lordship. Lordship, there are some other connected matters. I will provide the case numbers to the court master by end of the day and also give it to the landed counsel for the other side. Those may be listed on the next date and pleadings to be concluded. Counters to be filed on those cases.
Yeah, even if it is not concluded, we'll go ahead with the hearing, sir. It's very clear. List along with so and so on. 13th February, 13 February at 2 p.m. The matters will proceed irrespective of pleadings being completed.
Obliged.
Lordship, my lords, may I just request some indulgence, my lords? I've checked with Mr. Ganguly. He's, my lords, in an arbitration, my lords, and will not be in the country in the month of February. Can it be March, my lords? Any date as per your lordship's convenience?
All right. 13th March.
Very well, my lords. Deeply obliged, my lords.
Obliged.
Obliged.
That's it. All right.